Ohio, you may have your 15 minutes. We have read the brief, and we're ready to see when you are.
Thank you, Your Honor. Good morning. May it please the court, I'm Brian Bremer. I'm here on behalf of the city of Akron in this matter. The issue before you is a fairly straightforward one. The trial court in this case granted the motion to suppress that was filed by the defendant on the basis that the officers did not have reasonable articulable suspicion to run a license plate number through the Leeds database system. You do not, the law in Ohio is clear, you do not have a privacy interest in your license plate number. You do not need reasonable suspicion to run the license plate number through a police database system. On that basis alone, the trial court's decision was clearly error and it should be reversed.
Counsel, before you begin with the particulars, I'm looking at the trial court's judgment entry and what's attached to your brief, and it just says, for the reasons stated on the record during the March 27, 2018 suppression hearing, the motion to suppress is granted. So the trial court never issued actual findings of fact and conclusions of law.
It issued the findings of fact and conclusions of law at the suppression hearing. This court has previously held that those are, as long as they're specific enough, that is satisfactory for the court's obligations. In this matter, page 110, it starts in the transcript and it goes through like 111, 112. And essentially the trial court makes some findings that the officers stopped Mr. Moore before, and I guess I will get into the facts a little bit. The officers were responding to a phone report of a man going door to door with a bucket on Georgia App.No. And they responded to investigate that issue. The caller was at 815 Georgia Avenue. They saw Mr. Moore at 823. He did not match the description of the person that the caller called in, but he was the only person outside. So the officers basically called out to Mr. Moore and said, "Have you seen a man going door to door with a bucket?" And the officer said, and Mr. Moore said, "No, I've been at my sister's doing laundry. I just waiting for stuff to dry. I'm going out to my car real quick." And the officer said, "Thank you," and proceeded down the road. One of the officers in the car, Officer Bryan, I believe, decided to run the license plate number based on like the fact that no one else was out and Mr. Moore was the only person they saw. And when he ran the license plate number, the information came back showing that the license plate was a stolen car dealer's license plate. And the court found that all of this occurred. The court found that the officers credible about what the information was that they were conveying. The court had a problem with their decision to run the license plate number itself. And based on that information coming back that it was a stolen plate, the officers turned around. We were going to go back and talk to Mr. Moore. Mr. Moore, at this point, was in his car driving away from the scene, which was a little bit different. That didn't jive with the officer's belief that they were going to be meeting with him that he was staying to do his laundry. Like that's what he told them. And so now he's leaving. And they decided to initiate a stop to investigate the stolen license plate. It was during that stop that Mr. Moore told them his identity, and that's when they learned he had a suspended license, and that's when they issued a summons to him to come for driving under suspension. And the trial court said that when the officers crossed the line, the court said that speaking with him initially, there was nothing wrong with that. And since the appellee has never challenged that finding is in theory standing.
So when you say speaking with him initially, you're talking about it at the time whenever they had the report of the individual going from door to door with the bucket.
Right.
He was the only one around, so they asked him if he'd seen anything.
Right, it was a consensual encounter, or they initiated a consensual encounter. He responded, and they drove away. And actually, like that entire encounter ceased before they even had the license plate information. And that's when, and they drove away, and then when they came back, and that's when they actually initiated an investigatory stop and detained him, because they actually stopped his car at that point. But the court said where the officers crossed the line, that's a direct quote out of the transcript, was when they ran the license plate number without having reasonable articulable suspicion. This court has held that you don't need that. It is not a search to run a license plate number. You do not have a privacy interest in a license plate number that you have to publicly display on your car. And there's no suggestion in this case the officers came by this number in any way that is a violation of the Fourth Amendment. And even if they had, that would not make the running of the license plate number the problem. It would have been how they discovered that information in the first place. But the information itself they saw just on the car from the street when they were on talking to Mr. Moore. Further, and the other issue in this case, on top of the fact that the court's finding is, the court's determination is against all established case law in the state of Ohio, and I have not found anything on, beyond that that would indicate that this is somehow a search that would implicate the Fourth Amendment. This was never a ground actually moved on by the defense counsel in his motion before the court, or argued during the actual hearing. His motions was solely around the idea that when they initially stopped him, they didn't have reasonable articulable suspicion. And when you read the motion, it's clear that he uses a different set of facts than what actually ends up coming out of trial at the hearing. And so his motion is based on a little bit of a misunderstanding of what the facts apparently were in this case. But more importantly, then, even when at trial, he doesn't argue that the officers didn't have that the officers couldn't run the plate. He never argues that. He only ever argues that the officers, that he says all one encounter, and then he started arguing about it being an impermissible lengthening of the encounter when they started detaining him to investigate the license plate. And that was objected to by the prosecution, pointing out that he never moved on that issue. The issue was only about the initial stop, not about the length of the stop. And so when the trial court reached out and sua sponte found that the officers violated the Fourth Amendment by running the license plate number, the court went beyond the scope of the motion, violating Criminal Rule 47, and about putting the prosecution on notice about what the issues were.
And we're gonna find that in the findings of fact that were spoken at the hearing.
What's in the findings of fact? The objection's in there. The objection from the prosecution, and the trial court never made a finding on what was or what it wasn't in the motion. That never really fully was rolled on at the hearing. It was, but the court, when they objected, the court said, "I'm ready to make my findings," and then the court proceeded to make findings that were about the running of the license plate solely. They didn't. The court, beyond saying that the initial stop was fine, the court then said when they crossed the line was when they ran the license plate without having a reason to believe he was engaged in a crime. And like I said, this court in State v. Roberts, which is from 2012, and they discussed that issue. They said that you don't need reasonable suspicion to do that. That was reaffirming a case from 2000 that also had made a similar finding. Courts across the state of Ohio have also made that finding. You do not have a reasonable you do not need reasonable suspicion to run a license plate number.
Counsel, let me ask you this. I understand your argument in regard to what the prosecution has put on notice of what will be in the suppression hearing, obviously. But let's just do a hypothetical and say that somebody filed a suppression issue, or suppression motion, I should say, based on lack of probable cause to arrest. Okay, and there's a hearing, and the officer testifies, well, I pulled the red car over immediately because I saw a young black male driving. Now, nobody raises that. And he says that's definitely the reason he pulled the car over. Are you indicating to the court that that trial judge does not have the right or even an obligation to do something about that? I'm sorry to put you on the spot, but this is something I think about a lot in different cases.
No, I understand the question. I understand the potential problematic nature of that. I think under those circumstances, I would like to think that the prosecution would recognize possibly a concern
I would like
there.
to think so too.
But I would also say that there would probably be a necessity to move for a continuance at that point to try to let them raise that issue, and then it could be briefed before the hearing actually resumed. Because under Code Lupi, I think that had been waived by not raising it in their motion. So even though that testimony would have come out at the hearing, the court couldn't consider that when it was actually making its ruling. Of course, there'd be some issues with maybe objections, forfeiture, that sort of thing. But I think if the prosecution objected, there would probably have to be some remedy by the court other than ruling on that at the time right there. Unless there's any further questions, the city believes that the trial court's decision very clearly violates or is contrary to law, and that should be reversed on that basis. And we would even go further and suggest that there is no basis to grant a motion to suppress in this case, and we would request that this court sustain our assignment of error, reverse the decision of the trial court, and remand for the proceedings consistent with that. Thank you.
Thank you for your presentation today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides, as well as posted to our website and the Supreme Court.
Thank you.